Where is everybody? Okay, those that count are here. Where's everybody else? My goal is 25, and we're at 29 now. And we've got some tag-alongs up here, but
Sure.
but my goal as far as the official committee is 29, and I'm working on it. And anybody who wears a cowboy hat in the building, okay. Yeah, that's right. Bear Bryant wouldn't even do that, for those of y'all who are young enough, old enough to know who Bear Bryant was. Okay. We're in the process of setting day 28, Monday, crossover day. Needless to say, there will probably be 1-2 supplemental calendars for Monday. So we're down to the short rows right now, for those of you who are in farming and know anything about that. So I'm going to ask Representative Newton if he'll open us with prayer.
Pray with me. Father, thank you for the opportunity to be here today to serve you and to serve our fellow Georgians. Help us to do that with wisdom and with compassion, and help us as we reach out to others to help them whenever possible. Thank you for this time today. In Jesus' name, amen.
Thank you, sir. Okay, got a couple of items of interest that we'll do before we start listening to the request. Do I hear a move to recommit House Bill 30 to committee? We got a move and a second, it's gone. Okay. Do I hear a move to move HB 380, the Georgia Lottery Games and Sports Betting Act, from modified structured to structured? Got a move and a second. It's been moved to structured. Okay. That was easy enough. The longer I talk, the longer the line gets. I need to hush. Ms. Camp, give us your bill number, and remember this is 60 seconds.
Yes, sir. HB 532, LC 472154. It is a local measure to change the partisanship to nonpartisanship of the magistrate court judge in Pike County, Georgia. I have a resolution that was unanimously signed by all county commissioners and a letter of support by the magistrate judge.
Okay. Very good. No questions. Thank you.
Thank you.
Everybody else in line, take note of how much time she took. Come on, sir. Bring your partner up in
Yes.
crime up there with you. Mr. Jones.
Thank you, Chairman Smith. Representative Oliver and I are here to present the substitute to House Bill 520 that's on the second page, halfway down. Chairman Smith asked us to do this in 60 seconds, so here it goes. This is effectively building on the good work that this body did along with the Senate and the governor in terms of establishing a great foundation for mental health. To put it to the top of the waves, this would be the areas where I would categorize this. First and foremost, workforce development. Second, facilitating and making it more efficient for data sharing. Third, incorporating in a bed study so we know exactly where the beds are at, how they're being used, and how they're being paid for. And then fourth, effectively addressing a very important population within the state of Georgia, and this is around serious mental illness and familiar faces.
All right. Any questions?
Caption on the blue sheet, mine says building and housing and tenant selection.
What's the number?
520. It may just be that the caption's incorrect on the blue sheet. I didn't know if this was substituted for another bill or...
May I answer that, Chairman Smith?
Yes, go ahead.
Chairman Martin, there was, in the first version of the bill, my apologies, there was a Tenants' Right Act around criminal charges. That was taken out in the second version of the bill.
So that, it carries the caption forward.
Yeah.
That explains, yes, sir.
Mr. Green.
Thank you, Mr. Chairman. To Chairman Jones, you and I have had many conversations about South Georgia. How is this going to help us finally have some places to put individuals in South Georgia?
Well, a combination of things. First of all, there's an infrastructure study, or basically a bed study. If you look at section 6, and you'll see we asked the department to do an exhaustive study of the beds and also how they're being used, what type of beds they are, et cetera. But you have to be able to combine that with an appropriate workforce, because having beds alone isn't enough. You got to combine that with the workforce, and you go to the latter parts of the bill around, I think it's 15, 16, and 17, you will see we have a lot of provisions around licensing, around how it is that we can help our people who are currently licensed, who are facing challenges, and then also around a small subset of people, about 5 roles, that will be able to do loan forgiveness into the rural areas of our state.
Thank you.
Mr. Hawkins.
Thank you, Mr. Chairman. This next Wednesday, or possibly coming Monday, and check with me later, we're going to have someone come and speak to the Rural EMS Partnership with Emory Transport, who is set up right now in Randolph County. Very interesting in what they're doing, and will work very well with your project.
Thank you, Chairman Hawkins, and I'm going to go ahead and speak on behalf of Commissioner Tanner, which I probably shouldn't do. They are doing a pilot down in southwest Georgia, specifically around transport, so I think it'd be really interesting to see the lineup between Randolph County and what the commissioner is doing.
Yeah, Emory's using a federal grant on this group with Emory and a federal grant.
I'll be sure that Commissioner Tanner knows about it.
Okay, no more questions. Thank y'all.
Thank you, sir.
Mr. Parkle.
Thank you, Mr. Chairman. I am a farmer. I do know what short rows are. You love to see them when you're pulling weeds, not so much when you're harvesting. So depending on whether or not you're weeding or harvesting is whether you like them or not, and it applies to legislation. On the second page, the second one down, I have my bill, HB 458. It is a hemp bill. Some of you may recall, I just saw an eye roll in the back. Some may recall, I was one of 3 no votes on the inaugural hemp bill by Chairman Corbett. So why am I carrying it? CBD and hemp-derived products are not adequately regulated in the state. A 10-year-old right now can walk in a store and legally purchase a 100 milligram THC gummy. There's no database or record of how many stores sell hemp products, where they're made, or what is actually in the package. A recent JAMA study found that 76% of the hemp products tested were inaccurately labeled. The language in this bill is meant to provide consumer protections, guardrails, if you will. It does 2 primary things. It's a fairly long bill, but does 2 primary things. 1, all consumable hemp products must have a QR code on the packaging that shows the passing results of a full panel certificate of an analysis by an independent accredited laboratory. Secondly, it prevents the purchase of consumable hemp products by anyone under 21, including signage. So there'll be signage at the retail place. That's the bill, Mr. Chairman.
Okay. Well, I don't see any questions. Thank you.
Thank you.
Ms. Anulowicz.
Thank you, Mr. Chair. Thank you, members of the committee. I am here this morning to tell you a little bit about HB 382 for your consideration. It is second from the bottom on the first page of the blue sheet. This is a bill that provides for victim-centered restorative justice programs. It is supported by the Georgia Justice Project, Street Grace, which I know you all are familiar with because of their work with human trafficking, the YWCA of Metro Atlanta, the Georgia Coalition Against Domestic Violence, the Georgia Commission on Family Violence, and others, plus multiple members of the clergy from throughout the state of Georgia. The Prosecuting Attorneys Council has no objection to this legislation. It passed unanimously out of the House Judiciary Committee, and I would appreciate your favorable consideration. Thank you.
No questions. Thank you, ma'am. Okay, Mr. Williams.
Thank you, Mr. Chairman. I bring before this body House Bill 529. This is affectionately known as the Uber and Lyft bill, Transportation Network Company. This bill aims to bring the state of Georgia's TNC insurance code more in line with the national TNC insurance model. Currently, Georgia's insurance code requires TNCs to provide $1 million in uninsured motorist and underinsured motorist coverage for TNC drivers engaged in this service. This is higher than 42. This is high as 42 other states, so we're in line with California, New Jersey, and New York, and we had an agreement to change that. The National Coalition of Insurance Legislators had a model. All parties have agreed, and what we're recommending, the new language including this legislation, for uninsured and underinsured coverage of $100,000 per person for bodily injury, $300,000 for accident, and $25,000 for property damage. Both sides have agreed, so the insurance companies and the other side are all singing Kumbaya, and they're happy with this bill if it goes before.
Okay, well, thank you, sir.
Thank you, Mr. Chairman.
Mr. Ridley.
Good morning.
Morning.
House Bill 248 is on the front page, about halfway down. All this bill is doing is adding 3 more courts to that the sheriffs get paid for. It came out of judiciary unanimously. ACCG's in favor of it, and that's all the bill does.
Speaker Pro Tem.
Thank you. Mr. Representative, we had a bill, I don't know if you carried it last year, I can't recall. Did you?
Chris Irwin did. This is
And can you tell me the difference between this version of the bill and the version last year, the final version after it was changed?
yes, ma'am. So the one that I think the one that Chairman Irwin carried last year had the training stuff in there for to be able to be eligible to be a sheriff, and that's the reason it didn't make it. But this language was in there.
Well, my recollection is that it was more than just that. I mean, my recollection is that we modified the one last year where it wasn't 3 courts. I think it was modified down during the process. Is that correct?
That I don't know about.
Because 3 courts means 3 salaries, right?
That's
3 additional stipends.
Exactly. Well, it says up to 3. The actual bill says up to 3 additional courts, and they've actually adjusted the pay just a little bit. It's $385.90 per month.
Per court, per additional
Per court, yes, ma'am.
What the bill did last year, Speaker Pro Tem, it added 1 court. All right, I don't see any questions. Thank you, sir.
Thank you.
Mr. Leverett.
Good morning, Mr. Chairman, members of the committee. I've got House Bill 563, which is last on the list, but first in our hearts, I'm sure. This bill is a department bill. It's requested by the Commission on Equal Employment Opportunity, which is the commission that enforces civil rights and anti-discrimination laws within public employment in the state of Georgia. They have a process currently that's for hearing complaints that involves the appointment of a special master, which is generally a private attorney with some expertise in discrimination law to hear the complaint. That has gotten rather expensive, and so they are asking, the department is asking to move toward a ALJ process, just using the Office of State Administrative Hearings. So we're changing the language in the code to provide for that. The only time we would use the special master is if the OSAH is itself the respondent or the accused party, so to speak, in the proceeding. And then there's some other provisions that would allow amendment of complaints, because currently the law does not allow that, and that requires them to file additional complaints if additional facts arise. And there's also some provisions on discovery.
Okay, I'm going to give an exam on that. Thank you, sir.
Thank you, Mr. Chairman.
Hold on 1 second. Ms. Smith.
Thank you, and thank you for bringing the bill. In the past, I've had some opportunities to work with ALJ on natural resource issues, and I realize that a lot of them do not have specific expertise in subject matters. It's more of a rotation basis, so how do we ensure expertise here?
Well, I'm assuming they have some judges who can develop that level of expertise, and that's, I suppose, about all I have to say about that. I don't know that they have someone currently with that level of expertise, but I think the belief is an ALJ is perfectly capable to be educated during the course of the case on the underlying law and learn it, and that the current model is just not financially sustainable. Thank you.
Mr. Williams.
Thank you, Mr. Chairman. The gentlelady's question prompted a question from me because it causes pause when cost negates justice. Because if you're going to have hearing officers that are really not qualified, then it becomes a coin toss. And I understand the cost, but what is the price of justice?
Well, I certainly agree with that sentiment, Representative Williams, but I do not believe at all that administrative law judges in the Office of State Administrative Hearings are not competent to hear these cases and cannot adequately administer justice in each case.
Just one follow-up.
Yes, sir.
My experience has been, not being a member of the Distinguished Bar, is that there are pockets of expertise. I know a lot of lawyers that are way out of their bailiwick, and a lot of judges that just don't understand cases of this nature, and really, it's not a question of their competence, it's their knowledge that's in question.
Yes, Mr. Representative, when I hear you talk about lawyers being out of their league, it makes me worry you've been watching some of my cases. But I do appreciate the concern, and I'll certainly try to look into that and make sure. But I do believe this is something that the Office of State Administrative Hearings can adequately deal with and in a fair, just manner, and with a sufficient degree of expertise.
Okay. That looks like it. Thank you, sir.
Thank you, Mr. Chairman. Thank you, members of the committee.
Mr. Carpenter.
Thank you, Chairman and committee. I'm a little concerned. I don't see my bills on the list, but I'm going to go through them anyway because I got an invitation to the party, but it wasn't on the door when I got here. So I'm bringing two bills to the committee. The first bill is House Bill 355. It is a continuation of what Chairman Williamson carried last year on the right to fuel bill. This would just apply across HOAs, saying that they cannot prohibit natural gas or solar panels in an HOA. Obviously, they can restrict if they have to go on the house or in the backyard, and there are restrictions on solar panels. They can't go higher than the roof line. They have to be a certain color. They can't, if they're in the yard, they got to be in the backyard, and they can't go up to the fence. And so that's what that bill does, just saying we've got a move towards electric vehicles, and we need to make sure that consumers can properly have enough electricity to power them.
Okay. For those bill numbers he's presenting, they are on the yellow sheet.
Yeah, just didn't make the blue. Took me 27 days to get here, and I'm still on the yellow. I apologize.
Mayor Pro Tem, Speaker Pro Tem, excuse me.
Yes, sir. I had a couple questions. The first is, are you aware of any HOAs in Georgia that prohibit, I assume you're referring to natural gas, is that?
Yeah, the natural gas piece, no, but I think there's a current movement as you're building neighborhoods. I think there will be some covenants put in on construction.
Well, we may think there are, but are you aware of any that currently prohibit it in Georgia?
It's always good to get out in front of those things.
And number two, are you aware, did you consider, when you considered these, prohibiting HOAs from prohibiting the color green on houses?
I'm sorry?
Did you also consider adding a provision prohibiting HOAs from allowing or from prohibiting the color green on houses?
No, ma'am.
Okay, thank you.
Thank you.
Okay, what's your next bill?
Hey, that went well. All right, House Bill 404, Safe at Home Act. I feel like this one may go a little bit better. This is the first tenants' right bill that I've ever carried, but I'm excited about carrying it for this body. It does a few things. I'm going to go over them real quickly. First, it addresses security deposits at 2 weeks. It caps them at 2 weeks. That's the first time that's been in state code. I'm sorry, 2 months, sorry. There's a right to cure in there, and that would give tenants 3 business days to make sure they cure what they owe the landlord so they don't get evicted. It also makes it clear in code that during the eviction process, the air condition cannot be cut off on a tenant. And then finally, it establishes a warrant of habitability. This first time in state law.
Okay, well, very good. Thank you, sir.
Thank you.
What number was that?
404.
Okay. Yes, sir. Go ahead.
Chairman Smith and members of the Rules Committee, I have 2 bills from the House Judiciary Committee this morning. The first is House Bill 292. This is a follow-up bill concerning timeshares. Last year, Chairman Gunner carried a bill that you all approved that enhanced Georgia law regarding the 18 current timeshares in Georgia. This bill was brought because some national timeshare companies who want to do more business in Georgia would like to get some procedures that are more in line with national timeshare real estate law for the benefit of owners, lenders, title insurance companies, and this bill does that. However, we amended the bill in the Judiciary Committee process based on feedback from Chairman Gunner's district. It left intact everything you did last year, and this sets up some separate procedures for those national companies. South Carolina's number 3 in the country in timeshares. Florida's number 1. Georgia only has 18. This will bring more tourism and investment in Georgia real estate. That's House Bill 292, and we request your approval. The second, any questions on that bill?
I see no questions. Go ahead.
The second bill, House Bill 543, increases the jurisdictional threshold for 6-person jury trials in state court, not superior court, state court, from 25,000 to 100,000. Particularly with the backlogs from COVID, this bill, which was requested by the Judicial Council of Georgia, will allow twice as many civil jury trials to go on relatively smaller claims. 100,000 is a lot to me and my constituents, but going from 25,000 to 100,000 will let some of those smaller claims either get tried or settled more quickly, and we request your approval of House Bill 543.
I got a question. Were you trained by Wendell Willard?
Absolutely, absolutely.
Okay.
15 years ago.
For those of you who have not met Wendell Willard, great guy, love the man. Okay, go ahead.
Thank you, Chairman Smith. He's doing well in Highlands, North Carolina.
Thank you, sir.
Thank you.
Mr. Hilton.
Thank you, Mr. Chairman, members of the committee. I've come to here to present to you House Bill 453. 453 is the first bill on page 2. House Bill 453 is a small business bill that eliminates a license fee paid by all ambulance services here in Georgia. The fee currently is $2,500 per business, $1,400 per ambulance. For nearly 20 years, this program was designed initially as a provider fee, similar to our hospitals and nursing homes, where ambulance services would pay and receive matching funds in the form of higher Medicaid reimbursement. Unfortunately, that higher reimbursement never came, and so we are correcting this and returning those funds back to them by eliminating the fee. Also worth noting, today is EMS Day at the Capitol, so a great day to...
Okay, well, I don't see any questions. Thank you, sir.
Thank you.
Mr. Smith.
Mr. Chairman.
What's your bill number?
Mr. Chairman, I've got 2 this morning. First one I'd like to speak to is House Bill 549. And this is the Georgia Statewide Music Office Act. Under current law, really our film department under the Department of Economic Development is the main emphasis. Here in the state of Georgia, we have a long history in continuing pattern of excellence in the music industry. Unfortunately, though, our artists and our producers and a lot of our roadies, if I can use that term here this morning, they're being exported over to Tennessee, Texas, and Louisiana. And so this would actually put us on parity with the film industry here in the state and make sure that our musical talent, just to name a few currently, we've got Jason Aldean, Luke Bryan, who I don't go listen to anymore, among others, that, you know, we could have those individuals here. They're at a point in their careers now, Mr. Chairman. It'd be nice if we had something like this to support that infrastructure here in the state.
What department will this go under?
This would be under the Department of Economic Development.
Has the commissioner given his okay to this?
I haven't heard anything from him yet, Mr. Chairman, but I can always give him a call and ask.
Okay.
Thank you, Mr.
All right, what's your next bill?
House Bill is 267, and House Bill 267, just to be brief with the committee, I know y'all we're pressed for time. This is to make sure that we are correctly classifying workers here in this state. You got a lot of folks that are being classified as independent contractors that should not be. We're losing out on close to $575 million in tax revenue due to this. This makes the meaning in Matthew chapter 22, rendering to Caesar, this is making sure that everybody's rendering to Caesar the way that they should be. So.
Okay. All right, well, I don't see any questions. Thank you, sir.
Thank you, Mr. Chairman, members of the committee.
Okay. Chairman Martin, I think you have a bill. 249?
Yes, sir. We talked about that a few days ago, but 249 is an update to the college completion grant. We're properly aligning the percentage completion necessary to make students available. If you're in a 2-year program, right now the bill reads that you have to have 80% completion to be avail yourself of the grant. Obviously, if you're finished your first year, you're going to be around 50%, maybe a little more, not 80. So we're backing that down to 40. I think it's 45% to allow more students access to the grant. We're moving the 4-year grant from 80 down to 70 to provide students the way to finish. This just makes them eligible. They still have to go through the college office. We're adding additional funds, $3,500. We're going to get $25 million in the budget instead of 10 to help people cross the finish line and get to work in Georgia. That's what the bill does.
Yeah, anyone have a question? All right, see none. Thank you, sir. Anyone else have a bill they need to present? Lord have mercy. Mr. Whip.
Thank you, Mr. Chairman. Thank you, committee members, for allowing me to bring you House Bill 530. It is on your second page under Modified Structure Rule. 1, 2, 3, 4, 5, 6 one up. 1, 2, 3, 4, 5, fifth one up, excuse me. And this piece of legislation is what is commonly referred to as the Apex Doctrine. And what it does, it allows officers of large and complex corporations to defeat a request for a deposition. You know, and the proponents for the bill would like that if the CEO of GM doesn't have unique knowledge, they'd be able to get a protective order for that CEO not being deposed. And currently, under state law, our discovery rules are very broad. The Apex Doctrine is a federal civil rule of evidence, and we're implementing that in the state of Georgia to allow for businesses to defend against unnecessary depositions.
If anyone has a question, raise your hand. Mr. Williamson.
Thank you to the author of the bill. Is it not true that oftentimes these CEOs are high-profile corporate executives? It's more of a theater to bring them in, disrupt their business routines unnecessarily, whereas you stated they might not have any direct knowledge of the cause which is being litigated. Is that not true?
I don't know if I would agree with the gentleman's characterization of it being theater unnecessary, but I do believe that high-ranking officers of large corporations have unique and extensive scheduling demands, and those demands, if they don't have unique knowledge, should not be burdened by a deposition. If the party moving for a deposition can get that information from someone else. And to be clear, this is an officer, so it would extend to large corporations and large entities such as, say, the Department of Agriculture's commissioner. Extends both sides, public and private.
Anyone else have a question, raise your hand. Oh, Chairlady Smith.
Thank you. And as a layperson, not an attorney, could they still be deposed if they did take an action and have knowledge?
Yes.
Okay,
If they
thank
have
you.
unique knowledge, they still can be deposed. We're not removing the ability to just entirely do away with the deposition.
Okay, I don't see any more questions. Chairlady Ballinger.
Thank you, Mr. Chairman. I present before the committee House Bill 462, raise the age. It would just make sure that 17-year-olds are adjudicated in juvenile court. They're currently adjudicated as the same as adults.
Run that by me again.
This would allow for 17-year-olds to be adjudicated in juvenile court and not, as they are right now, adjudicated in state or superior court like adults.
Okay. The door was open and I couldn't hear. All right, any questions, raise your hand. All right, seeing none, thank you. Mr. Stevens.
Thank you, Mr. Chairman. On the back page, House Bill 557 allows PAs and APRNs to write prescription stimulants, Class 2 narcotics, for a 5-day supply. They're required to have a 1-year clinical experience before they're allowed to do this. They must work under a protocol. The only other state that does not allow this is Oklahoma in the whole country. Kentucky, with PAs, is the only one that does not allow, other than Georgia, to do this same thing, and it'll help our workforce as well.
Anyone have a question? Raise your hand. All right, we're on the roll right now. Mr. Lumsden.
Mr. Chairman, members of the committee, I bring you House Bill 541. Back page, fourth up from the bottom, LC 393750. This bill adds postal service vehicles to an existing code section that defines how a motorist approaching a sanitation vehicle doing curbside pickup is to respond. Like the sanitation vehicle, which travels in a stop-and-go fashion, postal service vehicles engaged in mail delivery also travel in a similar non-standard stop-and-go manner. All this bill does is adding postal service vehicles to an existing code section, and all of the provisions of the current code section apply.
If you got a question, raise your hand. All right, don't see anything. Thank you, sir.
Thank you.
Ms. Cooper.
Stuck. Thank you, Mr. Chairman. On the back page, fourth down, I bring House Bill 470. It's called the Georgia Candor Act. I would like to call it the Georgia Candid Act. It's a new way of handling, to err is human, and things do occur in the hospital where errors happen, and in doctors and other situations where you have patients. And this is a way, it's sort of an extension of our apology law, where you can go in and say you're sorry, but it puts safeguards around our apology law and sort of expands it. This would be where if it's voluntary on everybody's part, and if they decide to do it, then what happens is they come together. It's sort of like mediation, except the courts are not involved, and all of that expense of getting to that is not handled, where everybody comes to the meeting, the patient will get the records, whoever caused the error could be totally candid and say, I'm sorry, I made a mistake, I'm remorseful about it, what can I do, or what can we do to help you correct this situation? If everybody, either side is free to withdraw at any point, and go into the legal system, and go that route. But if they do, whatever is said in these candid discussions cannot be used in the court proceedings. This is passed in several states. It's working very well. In one of them, they have done over 100 with only about 3 of the cases that went on to litigation. And I'll be glad to answer any questions. And I want to thank the trial lawyers for working so closely with doctors and hospitals for us to come to this agreement after 18 months of studying it and looking what other people are doing to help the patients of Georgia.
Okay. Ms. Cooper, Ms. Hughley, you have a question?
If you don't mind, to Chairman Cooper, in these candid conversations, can they result in compensation to be paid to the patient as a result?
Yes, that can happen. And there is a time limit, of 2 years instead of something dragging out from 3 to 5. And I tell you, especially for doctors, one of the worst things they can have is this lawsuit or the thought of a lawsuit hanging over their heads. And as we study some of them why they're leaving the profession earlier, one of the things is the problem with lawsuits hanging over their head. And so one of our ways to keep more of our medical profession is to find ways to help resolve issues quicker and let them be honest. And also it helps increase patient safety. It might be something like it's in surgery and they want a bottle of fluids and the nurse goes to get it and she picks up the wrong one because they're right together. And by being able to, find this out and the people be honest, maybe what happens is they move the bottles from one group of bottles from this side of the room and one to the other so that this kind of accident doesn't happen again. And that is one of the reasons that this is especially needed, because we need for people to be able to admit their mistakes so that we can correct the system to keep them from having more mistakes. Sorry.
Ms. Smith?
I guess you can say I'm awake today, Mr. Chairman, but my question to this is it insurance that covers these payments? How are the insurance companies supporting this effort?
Well, the insurance companies would be, the hospital carries insurance and the doctors and people in the medical profession carry insurance. So that would be who would represent them in law. I mean, when the discussions, the hospital, the insurance lawyer would be with them in these discussions. Okay.
I just admire the talents of many lawyers to extend this type of effort as well, and I'm just curious, is there a trigger or something to not have this be a long-term other process not to pay? I'm just curious about that.
I don't understand about trigger.
So a patient might expect to have something resolved, but if the insurance company is not in agreement, even though we want to be candid here, can they extend or delay and create a similar scenario as exists now?
Right. Well, what happens is that they try to resolve these in 60 days. The patient or some person that thinks they're harmed has 150 days to engage in candor. That's 150 days from when they were harmed or they should have known they were harmed. Once that starts, they try to solve it in 60 days, but that 60 days can be extended if both parties agree. So they could agree to keep it going, but the time limit is of the 2 years.
Thank you.
Like that, so.
Anyone else have a question? Okay, seeing none. Thank you. Mr. Powell.
Thank you, Mr. Chairman. I bring to the committee today House Bill 353. We've been dealing with this issue for several years about cleaning up some of the operations in the COAM division. That's the coin-operated amusement machines. For years we've been talking about certain practices over there, and this bill does a few things. This allows gift cards for non-cash redemption. If y'all may remember last year in the debate on this, there was a lot of people who wanted to raise the tax on the highest taxed industry in the state so that more money could be brought into the lottery. I have no problems with that. I've talked to several of the folks about if this goes into effect with the non-cash gift cards, then we could have a pattern to see how much that tax may be raised on these folks. Increases the value of the Class A machines. That's what we call the kid games, the crane games and all. It raises the value of those to $50 for a prize. Puts the COAM division at the Georgia Lottery under the protection of the Administrative Procedures Act. There have been some events that happened as of late of the last several months of some errors and things that's gone on over there. Predominantly one of the hearing officers did a non-renewal instead of a revocation to one of these bad actors, for no better word I can say. They were going to be levied a $10 million fine, but because of threat of litigation, because of how they handled it, they were able to skate out with just the loss of the license. So this brings the COAM division under the Administrative Procedures Act. This exempts veteran and fraternal organizations so that they may put these machines in those type of organizations to raise money for their issues that the veteran and fraternal organizations deal with. And it also, one of the most important things, this would require that at any time that there is a judgment against one of these licensees, that their assets would have to go to public auction instead of being steered or directed toward someone else, which has helped to create a larger monopolies in quite some of these cases. And last but not least, this allows for some marketing. Currently, under the rules and regs over at the COAM division at the lottery, they don't even allow there to be signs to be put up in these places to remind folks these are non-cash redemptions. That's not legal unless it's legalized by the people of Georgia, and these are strictly non-cash redemptions. Be glad to stand for any questions.
Anyone have a question for Mr. Powell? Okay, seeing none. Thank you, sir.
Thank you.
Mr. Newton.
Thank you, Mr. Chairman. This is a bill that's it's not on the sheet, but it's in your book, House Bill 343. This is legislation we have discussed before. We did go back and perfect it. It's legislation to save patients money on their prescription by calculating their cost share, not on the list price of a medicine, but after a price that's adjusted down by a rebate. There were concerns over potential premium impact, so the amount was reduced from 80% of the rebate to 50% of the rebate. Once again, it still does not involve ERISA plans. There's an estimate out of over 14 million people in California on a similar plan with a 90% pass-through. The premium impact was less than 1/10 of 1%. So we think ours will be much less than that if we're starting with a 50% pass-through. This effort does involve a little end-of-the-year reporting as well to make sure that if there is a need to adjust due to premium impact, we could address it after this. But we think it's a great way to save patients money with minimal or maybe even none with better compliance. There might be no impact on the overall premiums.
Any questions? Mr. Park.
Thank you, Mr. Chairman. Chairman Newton, can you clarify, would this bill by statute permit PBMs to collect 50% of the rebates or refunds?
They're, once again, ERISA large employer plans where they have to disclose it through contractual agreements are left out of this plan. They have access to 100% of those rebate amounts now. This just requires at least a minimum of 50% be passed through for the patient's benefit.
Thank you.
Okay, I don't see any more questions. Oh, hold on, what is that, Ms. Cooper?
Thank you, Mr. Chairman. On the first page, House Bill 226, it was one that was recommitted to my committee. It's the one about putting people that are eligible for Medicaid and have HIV and they are HIV positive onto our Medicaid roll, like those that have a full-blown case of AIDS. I mean, we are the epicenter of the AIDS epidemic, and it's not just gay people. It's black, white, man, woman. It is spread through our whole culture. And if you are poor and you can't afford your medication, and you have really bad health care, you're much more likely not to be controlled. There are drugs, and if they're taken correctly, where people can be totally free of what transmits the HIV virus. So this is adding those people. There was a concern about, the bill was written that had it, if you were eligible for Medicaid, to about 137% of poverty, and there was questions about that. So the only thing that's changed is making that to 100% of poverty, our poorest of our poor, so that we can try to get a hold on this epidemic that we're having.
All right, I don't see any questions. Anyone else have anything to add? All right. Well, I guess we can set the original calendar for Monday. Under modified open, House Bill 532, do I hear a move? It's on. Under modified structure, House Bill 166, do I hear a move? Got a move, it's on. House Bill 249, do I hear a move? It's on. House Bill 267, do I hear a move? It's on. House Bill 458, do I hear a move? Got a move, it's on. House Bill 462, do I hear a move? House Bill 498, do I hear a move? It's on. All right. If you remember, we also recommitted House Bill 30, and we also moved House Bill 380 from modified structure to structured. Let me run this through you again. House Bill 532, 166, 249, 267, 458, 462, 498. That is the beginning calendar for Monday. See y'all in a few minutes.
What did you say that was those are from the ones you